Liebe Zuhörer, herzlich willkommen beim Wir für euch Kanal. Wir würden euch gerne über aktuelle Themen aus dem Arbeitsrecht informieren. Und das Thema für heute wäre leitende Angestellte nach § 5 Betriebsverfassungsgesetz. Üblicherweise kann man davon ausgehen, dass man so etwa 1-2% leitende Angestellte im Betrieb vorfindet. Es gibt allerdings auch Betriebe, die legen das etwas großzügig in Anführungsstrichen aus und bei denen durchaus bis zu 30% der Angestellten als leitende Angestellte definiert werden. Dieses hat weitreichende Konsequenzen, da ja zum einen zum Beispiel Regelungen aus dem Arbeitsrecht wie der Kündigungsschutz für diese leitenden Angestellten nicht gelten. Und darüber hinaus gelten auch Betriebsvereinbarungen nicht, die zwischen Betriebsräten und Arbeitgebern zum Wohle und Schutz der nicht leitenden Angestellten ausgehandelt werden.
Welcome once again to this episode on executive or leitende employees under Section 5 of the Works Constitution Act. We would like to talk today about the topic of senior employees according to Section 5 Betriebsverfassungsgesetz, the Works Constitution Act. And this is very important. We are really only concerned with the definition of senior employees or leitende according to this legal situation. And we would like to present here today in this video what the concrete implications of this regulation are for these employees and what you can do as a Works Council to improve the working conditions for these colleagues. But first we would like to answer the question, who is actually a senior employee according to paragraph 5 of the Works Constitution Act? There are 3 conditions. The first is a possibility of hiring and firing employees independently. Whoever can claim this is defined as a manager according to paragraph 5. Or another possibility, whoever has procuration, which is also not insignificant in relation to the employer. Or as a third possibility, whoever makes decisions free of instructions or significantly influences them. So, these are the 3 conditions mentioned in this paragraph in a or condition. And that is exactly what we are concerned with, this terminology. In some companies, this term is chosen in a very inflationary way. Here, this is illustrated graphically. As an example, 110 employees covered by collective agreements on one side. On the other hand, there are senior employees according to paragraph 5 of the Works Council Constitution Act, and 50 colleagues with this status for whom no company agreements apply. All in all, in this concrete example, this would mean a distribution of 67% collectively agreed employees or non-leitende employees and 33% managerial employees, a quota that is unfortunately very realistic in some companies in Germany. What does that mean in concrete terms if you belong to this 33%? What are the concrete consequences for these employees? On the one hand, there is only very limited protection against dismissal. For example, termination without cause is possible with severance pay. The protective rules of the German working hours Act on the subject of working hours do not apply to these employees at all. So, this 1/3 of the employees is completely exempt from these rules, and the co-determination rights also apply only to a very limited extent, as the entire Works Council Constitution Act does not apply to managerial employees. In this respect, one can say that the entire German labor law applies to these colleagues, to these 33% in this example, only to a very limited extent. And we ask ourselves, is that really what the legislator had in mind? If, to make it clear once again, a large German DAX company defines 1/3 of its workforce as executive employees according to paragraph 5, and at the same time talks about landmark rulings when it comes to clarifying this issue, then it is obviously trying to massively dismantle German and European legal and social standards. When works councils raise this issue internally, when they criticize it internally, they try to stir up fears in the workforce and to hinder the work of the Works Council. For example, the supposed executives are told that the rules are good for them, that it would be good if they became executives, that this is the only way they could experience personal development, otherwise they would be threatened with dismissal. And that is exactly the fear they are trying to stir up. The fact is that works councils can clarify the question of who is actually a manager according to paragraph 5. Let's make an example. A managerial employee according to the employer is now decided by the court. Either he is not a managerial employee, so he becomes a non-leitende employee, or he remains an executive employee. Those are the only two possible outcomes. There is no middle ground. There is no way to do it in a form as a compromise. Either you are a senior under Section 5 or you are not. If you remain so, nothing changes for the colleagues in that case. But when someone becomes a non-leitende employee, what happens in that case? We would like to go into this in a little more detail in this video. Let's go back to our example with the 67% of employees covered by collective agreements versus 33% of managerial employees. Let's assume, for example, that the labor court decides in 45 cases, it is out of the 55 in 45 cases, that these employees are not managerial employees. What happens then? In concrete terms, this means that these 45 colleagues move over to the side of the employees covered by collective agreement. The proportion then rises to 94%. A much more realistic figure. 6% senior staff would still be a very high figure if you look at many things such as the justification for the law and the like. But in this concrete example, 45 colleagues from the senior staff become non-leitende staff. What does that mean in concrete terms for these employees, especially in the financial area? We have listed 5 topics here: bonus, gratuity, retroactive salary increases, transfer modalities, and pension provision. In the cases of bonuses, for example, this means that these employees are no longer only entitled to their individual contractual bonus, which these colleagues often have in their employment contracts. These are not collective agreements that were negotiated individually. In addition, these colleagues would then also receive bonus benefits from company agreements. These apply to non-leitende staff, including all modalities for this specific group of employees. If, and this is always important, if the court finds that the criteria of a managerial employee are not met. The same applies to bonuses, such as Christmas bonuses or holiday pay. If the court determines accordingly, these colleagues, it as these 40 colleagues, 45 colleagues who are now listed as non-leitende employees, have a claim to bonuses from company agreements in addition to the monthly basic salary analogous to that of non-leitende employees. In the case of retroactive salary increases, there is a consideration in agreement bodies if works councils have appointed any. Retroactive salary increases according to paragraph 87 with a corresponding significant upside potential for all, really all, non-leitende colleagues. When it comes to defining transfer modalities to other companies within your group, works councils have often reached agreements with the employer. For example, what salary increases are necessary if one is transferred to another company or transferred by a transfer of business? The salary increases negotiated by the works councils in these transfer modalities would then also apply to these colleagues. And the important issue of old age pensions, where payments into the pension scheme would continue to be made in accordance with any company agreements or group company agreements, always subject to the proviso that if the court finds that the criterion of a managerial employee is not met. We summarize this again with the corresponding profit potential for these 5 categories, as just described. And one can indeed say that there is no downside at all for these colleagues, which we have also shown here in the summary. So all in all, any supposed senior employee who is now considered to be senior by the employer's view can really only gain if the labor court decides accordingly. So, in our opinion, a good works council and a strong trade union are needed to enforce the interests of the workers. We for you.
Vielen Dank für eure Aufmerksamkeit. Wir melden uns bald wieder bei euch. Wir für euch.